there are, since all the participants have switched off their camera, so I request if anybody can switch on the camera so the session can be interactive. Thank you, Vaishali ji. And it helps me a lot rather than speaking with a blank screen. If I can get enriched with your knowledge also, this will help. Thank you, Sunil ji, Chopra ji, Aishwarya Mohan ji. Thank you very much. So, there was a long introduction, but to cut it short, I am primarily dealing in the litigation. So to make the session interactive, I'm sure you people must have been dealing with the multiple assignments and must be facing multiple cases as such. So we can discuss the issues which are being faced by you and the law as well. Since the topic is very general in nature, I would propose to, unless I get a question, feedback, or some kind of enlightenment from all of you participants, I propose to take it section by section, which are the most litigated sections in the IBC, because IBC is a code which has given, or rather corporatized, the entire mechanism of resolving the insolvency. So first of it, like in the preface, it has brought few fundamental changes. And I'm just going to compare with the earlier existing framework. Earlier, if you want to liquidate a company, there was an office of office liquidator. Now, that entire infrastructure has been shifted to the resolution professional. So there is no official liquidator, but now there is a resolution professional. Official liquidator used to appoint various professionals to do the things. Now the resolution professional is appointing. The official liquidator had a dedicated counsel. Now it is being appointed by the resolution professional. So there is a corporatization of the mechanism. Secondly, the discretion which was vested with the court has been shifted to the committee of creditors. So committee of creditors is a new beast which takes all the decisions on the behalf of the company. Earlier, those decisions were taken by the shareholders of the company who were controlled, because the debtors in control was the concept. The debtors' decisions were very limited where they can take the decisions, and everything went back to the courts, where court used to decide whether the company is solvent or not, when it should be taken to the liquidation, and there are multiple other tests. Now, the discretion of the court has been reduced significantly. The adjudicating authority, which is NCLT, has significantly less discretion in many of the matters, like the resolution plan, etc., etc. Still, the power which has been given to the NCLT are very wide-ranging. So this has led to multifarious litigations. So if anybody has any questions so far, or want to enlighten us on any of the disputes they are facing, please feel free to switch on your mic and communicate whatever you want. Any questions so far? Or anything other than this is also welcome. Yes, sir. So you want to ask something, sir?
Yes, sir, just joined.
Yeah. Okay. So what I propose to do is, I will go section by section, which are the disputes which are coming up in the IBC before the NCLT. So first and foremost, the questions came regarding the applicability of the code on the pending cases. So there was a notification. Most of the pending cases now has been transferred from the High Court to the NCLT, and there are very few limited cases where the liquidation was at the advanced stage are left with the High Court. So this was regarding the Section 2, and there is very limited case law which is newly generating. These cases have already been settled. So these were the bunch of the cases which were their insolvencies were commenced kind of before the High Court. They went or traveled some path in the High Court. The companies were already in a distressed position. These positions were shifted to NCLT, and therefore the realization was less. Section 2 of the IBC deals with the various applicability, and 3 deals with the definition. There are few definitions which are very important and which are heavily litigated. The first of them is a claim. The definition of the claim is very wide. It says that anything which can be claimed from the company is a claim in a most simpliciter word. However, on and off, a resolution professional encounters with a situation where they are unable to determine what is the nature of the claim. 1. What is the quantum of the claim? 2. How far it should be admitted? And what would be the consequences of not admitting it? In first few things, the legal position is well settled that the duty of the resolution professional is limited to collating the claim as far as the insolvency resolution process is concerned. The collation does not mean adjudication. 2. What is the quantum of the claim? The resolution professional is supposed to make the best assessment and determine the quantum of the claim. Third is categorization of the claim. Whether it is a financial creditor, operational creditor, or any other creditor. The legal position as of today is that it is the duty of RP to put them into their respective categories. Sometimes it might happen that the form has been filed incorrectly, to point out, take the correct form, and they have to be categorized as per the definitions provided in the IBC. So what are the consequences of not doing it? So this is leading to huge amount of litigation where the operational or financial creditors are repeatedly filing applications against the resolution professionals, either relating to the quantum or relating to the categorization of the claim. As far as the concept of categorization is concerned, it deals with financial, operational, and other creditors as such. And the quantum is between the dispute between the parties. So once a party files a claim, he deliberately tries to categorize the claim at a higher level in waterfall mechanism. So if there is an interest component, even in the service contract, they try to put it in the financial creditors category. So it is the duty of the RP to put them back into the operational creditors. As far as the quantum of the claim is concerned, all the parties tries to mention the highest amount possible, which they can avail from the court of law, or they can claim, whether that is allowable or not. So it is the duty of the resolution professional to ascertain what is the actual amount, whether there is a corresponding clause for interest or not on those particular contract, whether it has been correctly calculated or not. In case there is a difference of opinion between the creditors and the resolution professionals, it inevitably leads to filing of the application before the adjudicating authority. Now, in India, NCLT, as well as all other courts, follows the principle of natural justice. Mere filing of the application by the creditors against the resolution professional does not mean or prove that anything has been wrongly or done by the resolution professional while admitting the claim. First, once there is a difference, the application will be filed. The notice will be issued by the adjudicating authority to the resolution professional, and the resolution professional has to give its reasons for arriving at a particular conclusion before the adjudicating authority. Unless there is a mala fide or wrongdoing, the adjudicating authority will look at the version of the claimant and look at the version of the resolution professional and decide the dispute between the parties. Sometimes these disputes can prolong for the years. For example, if there is a dispute regarding the quantum by the financial creditors, then, or even whether that particular creditor is a financial creditor or not, automatically it affects their voting right in the committee of creditors. Invariably, the people will move an application to stay the proceedings of the committee of creditors from taking further decisions in the CIRP, which will lead to the delay of the entire process. Therefore, it is important for the resolution professional to carry out this exercise very diligently. In case there is expert opinion required or they are not the subject matter expert, they are supposed to take assistance of the others and determine it. For example, and even if sometimes the best judgment is done or the best care is exercised, it cannot prevent these disputes. Reason being that being a financial law, IBC is continuously evolving from the day one. Majority of the cases which earlier came to the IBC were already disputed. So dispute was something which was inherent, inbuilt in the IBC, even before those cases came before the court. Normally in a court of law, the dispute is between the claimant and the respondent. But once the matter comes into the IBC, it becomes a dispute between all the stakeholders vying for the different interest. So the shareholders' interests are different, the creditors' interests are different, the suppliers' interests are different, and therefore the whole fight is between to take the largest pie of the cake, whatever is left on the plate. So this is how these things are working. So for an example, lot of these companies were builder companies who were in the business of developing multi-storied flats or the residential scheme and etc. There was landowner who owned the land. They did not sell the land to the company. However, they have taken the possession. They have agreed for a consideration on FAR, floor area ratio, or what they have agreed with the builder is that we are giving you the land. Instead of the money, you give a certain portion of the built up area, which we can sell off. So this was a kind of barter which was struck. And the question arose, what would be the nature of these creditors, or whether they can be called as a creditors and whether they are developers. Similarly, there was a dispute regarding in these land deals, there were a component built in for interest. Even for allotment of the flats, there was a component of interest which was built in. Whether they will be regarded as a financial creditors or not, this was the question before the court. So The resolution professional, the day when he resumes the or assumes the charge of a company as a resolution professional, he should be mindful of the fact that litigation is certain. Unless it is a prepackaged insolvency or a voluntary liquidation. In all other cases, the RPs is bound to face multiple litigation in one way or other. And since every stakeholder is at a different level in terms of his interest in the company, the conflict are bound to take place. And therefore, there are various applications which are filed. So typically, if you see the cause list of any adjudicating authority, NCLT, you will see that when the till by the time the application for the resolution plan comes up, there are 20, 30, 40, 50, or maybe more than that applications are there. So those are the one of few reasons for the litigation. Then the question arose, there are lots of litigation even prior to the commencement of the CIRP, which creeps into the CIRP. So the law says that there has to be a debt which has to be more than 1 lakh earlier, now 1 crore. Once there is a debt and there is a default, the adjudicating authority has no discretion but to admit the company in corporate insolvency. Now, the whole law investors that the adjudicating authority is not deciding the dispute regarding the quantum and etc. That is left on the shoulders of the resolution professional. So there might be a claim of rupees, assuming 50 crores before the NCLT by a financial creditor against the corporate debtor. He is unable to prove that 50 crore, but he is able to prove more than 1 crore is payable, which is not in dispute. The logical consequence of these facts will be that adjudicating authority will admit this particular company in the insolvency. Once the company is admitted in the insolvency, it will be job of the resolution professional to determine the quantum of the amount. And that quantum litigation will go on continuously till it is finally decided by the appellate authority or sometimes in the Supreme Court. So these disputes are bound to creep in, which existed prior to the CIRP. Similarly, the debt, as has been defined in the IBC, means obligation in respect of a claim which is due from the person, including financial and operational debt. So all the litigations against the corporate debtor in whatever form continuing before any court of law, be it a civil court, be it a high court, be it in the Supreme Court, all the recovery proceedings or other proceedings comes to a standstill and becomes a claim which is to be decided by the resolution professional. So this is how the total quantum of the dispute goes up significantly in the IBC. Any questions so far? It will be good if some of you participate in the discussion and keep the discussions alive.
Sir, in one case,
May
I continue, sir?
Yes, sir.
In one case, Honorable NCLT has rejected a claim as financial creditor. Then he filed a case in Section 9 operational creditor, and the case is admitted. So after that, he submitted the claim to RP. RP categorized it as an operational creditor only. So he disputed that case. RP has wrongly calculated, as admitted it is operation creditor. It should be a financial creditor, and he filed a case against the RP.
Right.
So of course, he fought that case. So in that such circumstances, when NCLT itself admits a case, whether it is a quantum or classification of the case, can RPA take different stand to that?
Great question. And this is faced by many of the resolution professionals. So you must keep in mind what is the role of the NCLT at the time of admission of the case. So in this particular case, or irrespective of this particular case, at the time of admission, what they are supposed to see, 1 crore rupees of debt and default. Whether he was a financial or operational, they may determine, but a debt may comprise financial as well as operational debt. So the responsibility to determine that category in respect of the total claim, how much financial, how much operational, and what was the quantum, is always on the shoulder of the resolution professional. Because at the time of deciding 7 or 9, the adjudicating authority is dealing with the limited question, whether it is falling in that right category and whether it is beyond the threshold. That's it, not beyond that. So they are not giving you the judgment that this amount is due and it has to fall in this particular category the entirely. So that's why that litigation is arising. So whenever you are deciding such dispute, you have to give your decision irrespective of getting biased by the observations in the NCLT's order. Normally they are right, but if they are not, or if there are certain new facts which have come to the light of the resolution professional, obviously the resolution professional has to decide it afresh. Thank you very much for the question, sir. It makes me a little bit happy because I feel a sense that somebody is listening. Thank you.
Yes, sir. I have
One more
a
thing.
can I?
Yes.
Stephen.
Yes, sir, Stephen, sir.
Yes, I have a small experience wherein the former RP was replaced by me as a second RP.
Mm-hmm.
And this was a case wherein some home buyers were involved.
Mm-hmm.
And while admitting the claims, some of the arbitration awards of certain home buyers,
Mm-hmm.
the former RP classified them as operational creditors,
Mm-hmm.
with regard to the arbitrational awards.
Okay.
Whereas at the same time, they were financial creditors also with respect to their principal amount claim.
Right.
So the classification done in respect of arbitration awards was other creditors, other than financial and operational creditors.
Okay.
So when I was appointed as the RP replacing the former one,
Mm-hmm.
then the home buyers, send a lot of letters to the RP, and I had to go for a legal opinion, and I took a legal opinion.
Mm-hmm.
And as per the legal opinion, which I received, they said it can be the categorization done for arbitration awards as other than financial and operational creditors is wrong. The nature of the home buyer's claim is financial creditor. So that has to decide, all their claims. For example, arbitration awards received by a home buyer, definitely it has to be a financial claim. So accordingly, RP, I reconstituted the COC.
Mm-hmm.
And now, you can imagine then that led into a lot of litigation, and because the balance will change, the committee of creditors,
Changed. Right.
voting percentage will change. So resolution plan in hand. So, so litigation is going on. So my CIRP is more than 2 years now.
It is bound to happen. So the thing is that this is an excellent example how the determination of the claim and categorization changes the balance and the fate of the CIRP as such. As far as the legal opinion is concerned, I feel that that is the correct opinion, because whatever may be the award, the categorization always be with respect to the original contract.
Exactly.
So since they were originally home buyers, so they won the award, means that their claim is quantified, but they still remains home buyers. So they have to fall in the class of the creditors.
Yes, sir.
And I'm sure that now the COC must have tilted in the favor of the home buyers, and the financial creditors must be outstood.
Yeah, which is being challenged now in NCLAT. So CIRP on a standstill now.
This is bound to happen. The only thing, you have to keep those dates now for extension of the time for all the times to come. It's difficult to resolve. The home buyers, the IBC was envisaged as one size fit for all. That's not the how the world works. And soon the legislature and the judiciary realized. So they carved out some exception for real estate companies. But still it is imperfect. So if we compare the Indian IBC with the IBC which is in force, say in UK, there the IBC is sector specific. At least every kind of industry has a separate rules and regulations, because the challenges are different. The power sector, the challenges are different. The real estate, the challenges are different. The consumer oriented companies, the things are different. So probably Indian IBC is also moving in that direction. So therefore, the slowly there are changes. The preferential transactions, 29A, special favor to the MSME. So it's going in that direction, and gradually we will see that the IBC will move from one size fit for all to sector specific IBC. That's something which might happen, but that is an inbuilt thing, and that's how the prior litigation creeps in, and even within that, the claims determination becomes really important for the IP. Now, post-claim determination, there is also some dispute relating to the applicability of the IBC 1 lakh and 1 crore. Ultimately, that dispute got resolved. Now it is that if somebody has filed prior to the change, then the threshold limit stayed as 1 lakh, and for the remaining, it became 1 crore. Then there are disputes relating to the, what is the dispute actually? Operational creditors, one of the biggest dispute is what is the dispute and what is not a dispute. So there are various judgments which comes up, and it continues even after the CIRP. A dispute has to be pre-existing from the date of CIRP as far as the admission of the claim is concerned. So if there is a communication between the parties, or their actions reflects that there was something which showed that the amount or the quality or the representations and warranties were not appropriate, that was a dispute under Section 7, and the petition cannot be admitted. The similar kind of disputes do come before the resolution professional. But the resolution professional's duty is limited to collating the claims. And since the claims are being collated, the resolution professional may not or is not required to go into the nitty-gritties as far as that is concerned. Sometimes these disputes become not so relevant where there are huge financial debts, but when there are only operational creditors in any particular company, the determination of such claims become really important. Then the next types of the dispute regarding the categorization only is regarding whether a person is I'll just second. So the next question which arises regarding the financial debt. So what is a financial debt? It is very easy to establish a financial debt when there is a proper contract between the parties. So there is a contract, one can determine that this is the amount as per the contract, but many a times, even the NBFCs do not have a contract. If somebody goes to the adjudicating authority rules, it is mandatory for the banking or financial companies to file the contract of giving the loan at the time of filing Section 7 application. In some of those cases where particularly few of the NBFCs were unable to produce that document, that proved fatal to the case of the financial creditors. Now, there is another kind of evidence which is really material here, is the balance sheet. Balance sheet of the companies sometimes or most often have the name of the creditors, that these are the creditors and this much amount is due. Sometimes that amount is not reflected in the banking channel transactions, and sometimes it is reflected. Sometimes that interest is not being paid, sometimes it's being paid. So, in some cases, the resolution professional or the adjudicating authority takes the view that they take evidences or some other document to ascertain the nature of transaction. Say, for example, it is written as a short-term borrowing, repayable on demand, etc. So that shows that this is a financial debt. Now, since there is no contract which is before the NCLT or resolution professional, the next task lies at what rate the interest is to be determined. Sometimes people came 24%, 48%, etc., etc. So, if there is no interest, then what is the position? So, Supreme Court in one of the judgments have come out with the thing that time value of money and disbursement are the important component of any loan. But time value of money doesn't mean only interest. Even if some money has been paid without any interest to be used for the purpose of the company as a loan, that will be regarded as a financial debt. So what is important is to look for those fine ingredients, whether that particular amount is a financial debt or not. So rather than going into the nitty-gritties of the lot of judgment, it is really important to ascertain the facts from the books of account which has been admitted by the corporate debtor to ascertain the nature of the contract and then categorizing the claims of the creditors. Here,
in the absence of interest agreement, what could be the other factor which could determine this as time value of money?
Yes. So if there is no contract, sometimes there is a deduction of the TDS.
Okay.
That will prove that, okay, at least in the books, it was regarded as a loan because you pay the interest against the specific provision that is an interest. When the TDS is deducted, it is reflected in Form 26AS, like most of the chartered accountants are very well versed with this thing. So this amount is reflected and it will show. So interest is not required, but once the amount is being advanced, there are communications. In one of the cases, there was a communication. One party is saying that this is the loan amount. Please confirm it. Acha, Sunilji was doing some personal discussion. I thought that he's asking some question. Okay, so this is how it works. So one has to find out which of the communications are relevant to determine this finer aspect of the thing. Then again, as we discussed earlier, the question came of the allottees of the real estate project. Now, this itself looks very simple proposition that anybody who has taken the flat or anybody who has taken something, they are allottees as such. But many of those projects are already complete and the possession has been handed over. And then it goes into the insolvency. And then the question will arise that who can file and what is the nature of the debt. So one of the proposition which is being argued, on which is argued, that this definition of allottees is interconnected with RERA. Allottee is as such is not defined in the IBC. It only refers to the RERA provisions that who are the allottees. The RERA goes one step further and says that those who have taken the allotment for cash or for the deferred payment and etc. But it does not take into account the project which has completed prior to a fixed date or otherwise, like where there is a dispute regarding the maintenance charges and etc. and etc. So all those people will automatically not fall in that particular category. And if there are loan transactions or if there are transactions, there are sometimes we can say the borrowings by the corporate debtor to avoid the financial liability. In many of the real estate projects, what has happened that the real estate projects got the stamp of some banking company to say ki we are offering loan in this project. The people borrowed the money from the bank and paid it to the builder. So the challenge was what to do with these kinds of transactions. Because on the one hand, the banks were trying to enforce the SARFAESI proceedings, but in order to invoke the SARFAESI, you need to have the flat which might not exist on the field. Two, these amounts were circulated. Exactly, the amounts were kind of a borrowing by the corporate debtor using the allottee as such. And in the projects are ready and they have been allotted to some third parties. So the dispute relating to allottee and the definition comes when the section 7 is there, 110, that is very simple. But after the petition has been admitted, the real responsibility lies on the shoulder of the RP to categorize these debts. In one of the cases, which is right now going before the Supreme Court has restrained some of these financial companies from enforcing these debts against the individual home buyers. That is still pending in the consideration, and that is yet to be decided. So whenever the issue comes, whether there are a class of creditors or not, the resolution professional has to ascertain the applicability of the RERA on those particular projects. Then the next things, which is very often litigated and which is something close to the heart to the all resolution professionals, is insolvency resolution process cost. This is also part of section 2. Most of the dispute relates to the non-payment of the fee. Sometimes the dispute relates to the payments to the people which were taken on board by the resolution professional. So, and what is the part of the resolution process fee or not? So now there is some clarity which has come up in the regulations where they say that certain kind of expenses has to be approved by the committee of creditors. So more powers have been given to the committee of creditors. Then the disputes arose regarding the exorbitant amount sometimes claimed by the resolution professional. So there was some case in the beginning where one party has put up a claim of 5 crores of rupees for dealing with one insolvency where total amount of debt was 11 crore only. So that was that resolution professional was removed, etc. But there are genuine cases where most of the cases there are genuine, where a lot of time and effort has been put by the resolution professional and they are not getting paid. because either the COC is not paying or corporate debtor doesn't have the assets. So all these cases initially used to be referred to the IBBI. Then the things changed. The Supreme Court decided a few cases in which they asked the adjudicating authority to decide this dispute. So it is coming back. Now, again, the clock has turned back and the matters are being referred to IBBI to decide those claims, whether that has to be paid or not. But the central focal theme of this is that there is a perception gap between the resolution professional and the adjudicating authority. Many of the judges in the adjudicating authority believes that professional fee has to be commensurate with the assignment, 1. 2, they also feel that if a professional is not getting paid for work done, then nothing is extraordinary wrong is happening. So they are comparatively relaxed on enforcing those contracts. At the same time, the resolution professional has a perception because it is not only his time. Managing a company as a going concern requires payment to the multiple people, and it consumes a lot of time where he has to sacrifice his other professional assignment to keep those CIRP running. The mechanism which has been evolved by the IBC is, in my opinion, is not foolproof. Reason being, the IBC says that the resolution professional is as such an independent, but they have given the responsibility of making payment to the financial creditors. So a good number of time, the resolution professionals has to make sure that the financial creditors does not get offended, so he can get his remuneration. Since this is a pure conflict of interest thing happening between the financial creditor and resolution professional, therefore this entire thing of fee is coming up. Sooner or later.
Sir, may I interfere?
Yes.
What would your suggestion, like in case the RP is not getting payment from the COC member? Basically, say 95% of the COC is owned by, the share is with one financial creditor. And if they are not paying, then what do you suggest? Report to IBBI or go to NCLT direct?
Both.
Okay.
Both. Reason being, the judiciary the situation was really worse when the initially 2016 and 17, they were not paying at all, and even the advertisement fee was going out of the pocket of the resolution professional. So the solution evolved by the judiciary for the benefit of the resolution professionals, that they started paying upfront amount of 2 lakhs in Delhi, 5 lakhs in Mumbai. So at least initial cost is paid. Thereafter, there is a contract between, say, resolution professional and financial creditor when he is made from IRP to RP, and then that contract can be enforced. So that was the original thinking. But still, what if? So in one of the cases I dealt with, one financial creditor was having like 70% of majority in the COC. A person was appointed as an RP, and immediately he found out he is not even a financial creditor. He changed the category. He immediately changed the category and fund flow stopped. New person was inducted in place of, like, the other people who were actually financial creditor came in and they replaced the RP. So the thing is, the law as such has not been designed to do wrong, but it is actually doing wrong because there is a conflict of interest between the two entities, which is part of the same process. So as soon as there is a delinking of the fee, as in the case of the first 30 days by the IBBI or IBC, where they are paying upfront 2 lakhs and 5 lakhs, the independence of the resolution professional can't be ensured as such, because you can't fight with the person who is feeding you. That's the reality of the life, whatever it may be, howsoever it may be said. So that something has to change. But the question is right. One has to take all the remedies, but not to go after remedies by sacrificing your own time, effort, and etc. So in one of the litigation I was involved, where the RP first filed for the in NCLT, then he went to NCLAT, then the Supreme Court, the matter got remanded back. He again went to NCLAT, then he went to the Supreme Court. That's in circles and circles it is happening. In another case, in one of the symposiums which took place in Bhubaneswar, another resolution professional was saying that RP got the resolution plan approved. And because of the litigation, there was a delay in handover of the entire company from the date when the plan approved till the litigation got concluded of 2 years. So the RP is due from the perspective, from the actually successful resolution applicant is 2.3 crores. And the successful resolution applicant has filed a claim against the RP for 54 or 56 crores of interest because of the amount he has lost in that litigation. So that's an unfortunate situation, but the problem lies in the conflict of interest, and unless and until it is resolved, the RPs have to be conscious that all the apples in a particular basket may not be good. Some will be bad, some will be good, and that's how the life runs.
Sir, one more question. In case you are not getting paid for the entire CIRP period, and if liquidation is decided, what do you think ideal time to make your complaint or report to IBBI about your remuneration?
Okay, so that's a very good question. All the complaint has to be made as soon as possible, irrespective of the outcome. So what happens is that many of these claims get washed out because of unreasonable delay or change in the parties. So when it is sure that you are going to fight the war at some point of time, it's better to prepare as early as possible. So keep your communication continuous. Keep continuously communicating with them. First reminder, second reminder, third reminder, fourth reminder to the IBBI, file an application before NCLT, non-compliance, file a contempt. Let it be. Because that's something, if you don't do it, they take it as like, ho gaya. They will never be interested in making the payment because the RP has been put in such a situation, so he is enemy of all. Because at some point of time, the interest of everybody is colliding with the interest of the RP. RP is taking money out of the company to run the company and as his professional fee. And this money is technically going from the pocket of the stakeholders. So there is a conflict inbuilt in the provisions itself. So they are never going to be happy with the RP, whatever the RP might do. And the first thing is not to pay. Yes, sir. Someone was asking a question.
Sir, in my case,
Yes, sir.
what we did is that I met all the expenditure from my pocket. Of course, when the company went into liquidation, so there is some realization out of that. And I could realize my, because CIRP cost is on priority, I realized all my outstandings.
Okay. So you were lucky.
Yes, sir.
So
Sir,
sometimes,
sir, myself Sunil Agarwal, but the most of the cases in the beginning, you will not receive the CRP cost from the COC members. But at the conclusion of the CRP proceeding, you will receive the CRP cost. Even after the liquidation of the company, then you will receive the CRP cost and the liquidation cost. In the so many cases, in the beginning, no COC member is the interest to make the payment to the IRP fees and expenses.
yes, this is happening in most of the cases. Yes,
Yes.
the realization if the person can keep the patience, but in some cases the cases last forever. So
Yes.
many of the insolvency professionals are facing that difficulty where like for 2 years, 3 years, 4 years, 5 years, that has not been paid.
Yes, sir.
But
In one
fundamentally, you are absolutely correct, sir,
of
that
my
if there
cases,
is a
in one of my
yes,
cases in
Sunilji.
2019, sir, why the one of the case of the starting from the 2019, even till today, I have received only the 5% fees, and the 95% fees is under the litigation before the NCLT court. So the banker has not paid till now.
Yes. So have you filed a contempt against them?
No, the matter is the regarding some withdrawal of the case. The case filed by the operational caters, but the operational caters has not submitted their claim on the commencement of the CRP, and the financial caters has submitted their claim. So that the 100% voting rights of the financial caters. Only the one of the meeting of the COC is attended by the financial caters. Thereafter, the no COC meeting is attended by the financial caters. When the CIRP was continued up to the 6 or 7 months, we have called the so many COC meetings, but they have not attended. But we have completely, from the beginning, we have reported to the NCLT court. So in the last, after 2 years, that we have received that we are withdrawing our claim. No person can withdraw the claim. If you desire to withdraw the claim, you submit your necessary application before the executing authority for withdrawal. So then they have filed the necessary application with the withdrawal of the case. But the 2 years has been passed after withdrawal, but this is pending before the executing authority. So now in this case, the 2 years has been passed submitting the application of withdrawal. Then for this 2 years, then we may charge the fees of the as a IRP or RP.
Sir, this is really subjective. The fee, sometimes what happens is that fee is agreed in different terms. One, you agree on a monthly basis, one you agree on the assignment contingent basis. So it will depend upon your facts how you want to fee. But if there is no work done, it is very difficult to get any fee approved from any authority. So the challenge is that when there is a settlement going on and the amount, there is hardly any management of the going concern, the adjudicating authority as well as other appellate courts are most reluctant to give any benefit to the resolution professional.
Yes, sir.
That's the basic problem. So whether you will realize or not will depend upon the fact that how far you are able to convince the adjudicating authority that despite in that long period of time, your efforts were involved in running the company. If there were efforts, the adjudicating authority will take a favorable view. If this is not the impression the adjudicating authority are getting, they are not likely to approve the fee.
Yes, in the most of the cases, the company are not in the working. That the so many companies is a commencement of the CRP. Only the maximum 5 or 10% companies are in working, and 90% companies are not in working.
Yes, that's the problem. They are not working, and therefore there is a question: how far are you able to justify your fees? So that will remain problematic because of the system. It is yet to be perfected by the law. So the
Yes.
law is evolving. It will further evolve, but that is right now there is no clarity how it is to be done. So even in just like 12A cases, when there is a settlement is taking place, normally the NCLAT take the view that, okay, pay this much of amount, lump sum 2 lakhs, 3 lakhs, etc., whether it is for 2 months, 3 months, 5 months, or 1 day or 2 days.
Yes.
Okay. So there is an amount which is decided by the adjudicating authority with the consent of the parties. Okay, you take this amount. And it's best, it is at that point of time, you don't have a choice.
Yes, that is the right approach.
Right or wrong is very difficult thing, because one thing may be right for one person, it will be wrong for another person. So in law,
Yes.
it is always tricky. But the idea is, since there is no certainty in the law, so the outcome cannot be predicted.
Yes.
So that's the situation. So you are absolutely right. This is what is happening in the present cases. And this is the challenge which every resolution professional has to face. And there is no escape from it.
Yes, sir.
Thank you, Sunilji, for your question. Anybody else has any other comments so far? Okay, so let me proceed further. So another heavily litigated section is section 7. Now the quantity of the section 7 applications has gone down significantly. The first fall in the section 7 applications came when the limit was increased from 1 lakh to 1 crore. Then the things like there was a change in the thinking of the people that if there is a default, there will be a recovery and everything would be coming. So again, the second fall came after the COVID period, where most of the people are not instituting the section 7 applications because they feel that the realization might not be that good compared to the cost dynamics. So the bankers are thinking that it might be cheaper for them to invoke the SURFACE or etc. rather than going to the IBC. But be that as it may be, if you see the list before the NCLT, nowadays, then most of the applications are 95, 96, and all the applications under section 7 and 9, they are of earlier years. The fresh institutions of these cases have come down drastically. Then the next litigations are, which is coming in the sections, is 10A. 10A deals with a period where the initiation of the CIRP was in a particular COVID period, and therefore there was a moratorium given. So there was a continuous cause or not. On these sections, there were litigations. Then another application which every resolution professional is supposed to make is under for extension of time. So none of the CIRPs are getting completed within a period as envisaged in the IBC. So they are supposed to move an application for extension of time. And most of the time, the question of the court is twofold. What is the stage and what you have done so far to resolve the insolvency? So in order to avoid these queries and any further complications, it is advisable for the resolution professional to file their report, the progress report, on systematic intervals, keep on their compliances, and must be able to show the progress in the CIRP process. And that will avoid all these litigations which are taking place. Then the next section where a lot of the litigation are coming or coming to end rather is 12A. 12A, I want to dwell to some 12A is a section which allows the corporate debtor to enter into a settlement with the creditors, one or all of the creditors, wherein the corporate insolvency can be put to an end by 90% of the consent of the financial creditors. Now, the first such challenge of 90%, what constitutes the 90%, comes into the real estate companies. Because in case of class of creditors, there are provisions which says that you have to take 51% of those class of creditors as 100% and they vote in a favor of a particular resolution plan. Some of the 12A got approved like that. However, one such dispute reached to the NCLAT, wherein the class of creditors voted in the favor of the resolution plan, but since the number of the people voted and the 51% of those people were very less compared to the entire number of the stakeholders which were going to be impacted by such vote. So the NCLAT was asked to determine a question whether they should go by the voting percentage rule, which is applicable in the class of creditors, or 12A. Taking into consideration all the facts, as of today, the NCLAT has decided in case of 12A, this class of creditors rule where majority decides for all of them is not applicable, and consent of the 90% of all the members of the COC is compulsory. So as of today, the home buyers companies cannot get their resolution plan approved merely by taking the consent of class of creditors 51% and take their ratio in the committee of creditors to arrive at the figure of 90%. Secondly, what was the result if there is a settlement between only one creditor and the other creditors doesn't want to be bound by that settlement? So that questions are still to be decided at the level of FX court. There is a judgment of the NCLAT and it went to the Supreme Court, where the NCLAT took the view that 12A cannot be used as a mechanism to bring in the resolution plan at this stage without getting it scrutinized as per the provisions of Section 30. That was the judgment of the Siva Industries case. Later on, when appeal was filed in the Supreme Court of India, the Supreme Court decided that in case there is a settlement among all the stakeholders, then it is binding on all the members, irrespective whether they have assented or not, and adjudicating authority cannot sit in the judgment as far as the 90% of the creditors has approved that plan under 12A. The third category of the disputes which are coming under the 12A is the non-compliance and the payment of the fee of the resolution professional. So in case of non-compliance, now law has more or less settled that the proceedings can be revived where the settlement has been agreed, but it has not been fully implemented. 1. 2, as far as the fee of the resolution professional is concerned, it is better to get it decided at the stage of the 12A and get paid. Otherwise, it becomes really difficult to recover because now it is less than 1 crore in most of the cases. And even the resolution professional cannot initiate the insolvency proceedings against the corporate debtor. So be that as it may, the thumb rule is 90%. Once the 90% is there, the adjudicating authority cannot interfere. And as far as the voting percentage of this particular section is concerned, it will remain 90%. So far we have covered till section 12A. Any questions?
Sir, before constitution of COC,
Hmm.
if there is a settlement between the creditor and CD,
Yes.
so 90% don't come now, sir.
Yes. So that would be governed by the judgment of the Supreme Court, where it says that as long as the COC has not been constituted, there is no need of 90%. The parties can settle by themselves. So no 90% is required. Absolutely correct, Venugopalji.
Thank you, sir.
Thank you. Thank you for that question. Now, the next important section is moratorium and the impact of the moratorium. So as soon as the CIRP process starts, the moratorium comes in the force. There are the immediate thing is the shareholders loses the control of the company. So good number of time they try to take out the assets of the corporate debtor from the factory in the form of the cars. The cars is one of the most prevalent litigation, and in any other form, even there are withdrawals from the bank account. So as soon as any such activity is noticed by the resolution professional, which has taken place after the commencement of the CIRP, they are supposed to move the application before the adjudicating authority for recovery of that amount. There is the adjudicating authority always takes a very strict view of any such activity done by any person belonging to the company in whatever the capacity. So the first effect of the moratorium is these pros. There cannot be any siphoning of the funds or the taking out of the assets. The second effect of the moratorium, that all the proceedings which were going on against the company for recovery of any amount comes to a standstill. So as a resolution professional, during the CIRP, he is supposed to intimate to all the courts wherever the disputes are going and give them the orders of the NCLT that this particular company has been admitted into the CIRP, corporate insolvency, and therefore these proceedings cannot go. However, there is an important distinction here. The distinction is if the company has filed the proceedings for the recovery of certain amount for the third parties, the moratorium is not applicable. So the resolution professional is bound to continue those proceedings which are beneficial in nature to the corporate debtor, because he is the custodian of the company and he is taking over the company and running the company for the stakeholders. So he cannot allow the net worth of the firm to erode and therefore has to continue the proceedings. The central theme of the section 14 is to preserve the value of the company. Even a good number of time, the CIRP is invoked by the people to avoid the SARFAESI proceedings. So that is there. The whole idea behind this section is preservation of the value of the company. So even the government contracts can't be, government leases can't be terminated. Essential supplies cannot be terminated. And if there is any such thing happening, then immediately the application has to be moved to the NCLT, and NCLT will pass the necessary order to protect the interest of the stakeholders. So after this moratorium, there is another issue which comes regarding the claims. When the claims are invited by the resolution professional, the resolution professional is asking for all the information, but there is hardly any proceedings taken up by the resolution professional against the people who are filing the false claim. So that is one of the provisions which the RP must bear in mind. And when the need arises, can be invoked, that if a person is filing false or misleading claim, the resolution professional can and should take actions against such people. Yes, Aishwarya ji.
Hello.
Yes, sir.
You are saying that in case of the false or false claim was filed, we should take action. But on the other hand, RP duty is to collect and collect only. So, first thing, so where it arises, I know it is written in the law and even in the bottom of the form it is given. But when our duty is to collect and collect, why should we bother to file this litigation? Secondly, as we are in doubt, we just ask the information and do not add their claim in this approved list. Is not enough and more practical.
So,
That is only.
so actually, this is something which happen in some of it's what you are saying is absolutely correct. The resolution professional may not resort to this thing, they can only reject the claim, but there are cases where what happens is that the false and inflated claims are filed. These claims, when you cross-check with the ex-management of the company, they say that these are false and thing. So if action is not taken by the resolution professional, then there is a section 70 of the IBC, which might lead to problems for the resolution professional. Section 70 provides that if this kind of information is provided to the RP and RP fails to take an action, then the RP himself can be penalized. So it might be in the interest, it will always be in the interest of the resolution professional as well as the interest of the company, if there is a conclusive proof that the claim submitted is false and fabricated, the action should be taken by the RP against such people. If the RP doesn't take an action, there is always a sword hanging on the neck of the resolution professional that somebody might file a complaint against the RP using that particular section. And that's why it becomes assumed significance. I hope that answers your question, Aishwarya.
Yes, yes.
Yeah. So thank you very much for the question. And right now, everybody has switched off their camera, but such question gives me hope that somebody is listening. So next is, thank you very much. Thank you very much, sir. So next section where the litigation happens is management of affairs of the corporate debtor, and what would be the roles of the ex-directors and the RP. This is section 17. So first and foremost, the effect of the stay, which IRP takes control of everything. Then powers of the board is suspended. So sometimes there is an inbuilt notion in the community at large that the person who was running the company is at fault. He has taken out the money. That's why it led to the collapse of the company. That presumption is incorrect because IBC does not entertain any such notion. IBC is even for the person where there is an honest failure of the business. And therefore, the company went into the insolvency and it is being resolved. This means that IBC only suspends the power of the directors of the company, but it doesn't mean that they are relieved from their responsibility, or the resolution professional can disregard them altogether and treat them as an accused in a criminal proceedings. That kind of approach is not in consonance with the objective of the IBC. So IBC still requires the management of the company, ex-manager of the company, to cooperate with the resolution professional. At the same time, expect the resolution professional to take into account all the information which has been given by the ex-management. It becomes really easy to manage the company when the cooperation of the ex-management comes in. Because this is deep, this is interconnected with the last question which Mr. Aishwarya ji posed, that what would be the implication. So if these people who were running the company so far are not taken into confidence, it is impossible for the resolution professional to achieve a quick resolution of the company, because they know the vendors, they know the obligations of the company, they know the business, everything is more or less under their control. And sometimes the books of accounts and getting the information is another challenging task. So one of the application which every RP moves is section 19, non-cooperation. Non-cooperation because the information is not being provided by the ex-directors, or there are nobody to provide that information. That information, it's very challenging task to get that information. Yes, that's the problem. Two, another problem is that the correct list is not provided sometimes by the resolution professional to these people. Many of these people become completely helpless after their accountants move out of the company, and they had no idea what has transpired in between. So the seeking of the information, the collation of the information from the ex-management has to be very systematic process. And wherever the information is not being provided, there has to be reconstruction of the accounts basis upon the bank statement, etc. of the company. And that will avoid some of the litigations. Another thing that they are not part of the decision-making process, but they can participate in the COC meeting and in the waterfall mechanism. Though they come at the bottom, still they are part of the waterfall mechanism. So all the requisite information which is available to the COC and can be legally shared with these people must be shared. So multiple litigation arose whether they can participate in the meetings or not. Then whether the resolution plan can be shared with them or not. Whether they have the right to participate in the resolution process or not. So now the things have settled out in most of these propositions that yes, they have to be, they can take participation in the meetings. The information has to be shared. The resolution plan has to be shared. Only the confidential documents can't be shared with them. And if they are an MSME, they can give the resolution plan. Only they cannot if there are some proved violation as per 29A. So those are the litigations which more or less now has settled under section 70. Someone just now pointed out the duties of the resolution professional collating the claim. Yes, there is a collation of the claim. Then in collation of the claim, one of the issues which has arose and which will arise is that sometimes the people do not file the claim, but they are reflected in the books of account, whether they should be treated as a claim. Yes, now the answer is in the affirmative. They are the claimant and they should take claims. Then
So just a small question.
Yes, sir.
So just sometimes back, you just said one point that while sharing with the suspended board members, so even the relation plan, other things should be shared. The only exception you said was certain confidential matters. But I suppose on that also, it's very clear the confidential matters can also be shared if we take a confidential undertaking. I would request a clarification on the same, please.
Yes, so you are absolutely right. If you take an undertaking, it can be shared.
So that's the latest change we have.
Yes, that is the latest change. And further, I think there will be further changes because the system is now moving to the more and more transparency. Even the resolution plan was not shared earlier.
Precisely. Thank you. Thanks.
And that should, this is my personal opinion, but I feel that I think the person who was running the company knew almost everything about the company.
He is the best person who can guide you on many things,
Yes. So every information which is being prepared must be shared with him.
I'm there with you, sir. I'm there with this view.
Yes.
Thanks.
Thank
Sir,
you.
one query, sir.
Yes, sir.
This section 70 is punishment for any officer of the corporate debtor who does not comply with the ABCDEF.
Yes.
Not with the resolution professional, sir.
Now you have
Here
asked.
it says on or after insolvency commencement date, where an officer of the corporate debtor ABCDEF, he shall be punishable.
Just a second, sir. Let me read. I read it some time back. Just give me a second. I'll point out the specific provision which I was referring to. So, just come to the clause 2 of section 70,
Yes, sir.
it says that if an insolvency professional deliberately contravenes the provision of this part, the shall be punishable with imprisonment for a term which may extend to 6 months. Okay, so this part has to be read with the first part. The first part deals with on or after the insolvency commencement date, where an officer of the corporate debtor, so they are regarding IP as an officer kind of thing, okay, does not disclose to the resolution professional all the details, does not deliver to the resolution professional all part of the property, does not deliver to the resolution professional all the books, fails to inform their solution professional the information in his knowledge that the debt has been falsely proved by any person during the corporate insolvency resolution process. So here that section get triggers. Okay, so the director is duty bound to tell you that somebody has falsely proved the debt. Okay, prevents the production of any books or papers affecting relating to the property affairs, accounts of any property, etc. till date. Then the section 2 comes. So that's how the three things has to be read together. First, they said that these are the duties. And secondly, says that if an insolvency professional deliberately contravenes, so when the insolvency professional can deliberately contravenes, it will not be in the case of first three.
Yes, sir.
Because first three, somebody else is obliged to give to the resolution professional. But in the fourth one, somebody is giving, but insolvency professional is not taking the steps.
Okay, sir. Okay, sir.
Am I clear now, sir?
Yes, sir. Yes, sir. Thank you, sir.
Yeah, so it's very circular preposition, but it connects the three sections. So if this is for a specific circumstances, when somebody is giving you the information that the debt has been falsely proved, and despite that information, the resolution professional is not taking step, then there is a section for imprisonment.
Thank you, sir. Thank you, sir.
Thank you very much, sir, for that question. So sometimes the law get tricky and it's far from obvious, which should be the case. So we were close to section 18. Any other questions, sir? Anyone? Okay, so we'll move forward. One of the application which one is supposed to make as an RP is taking over the control of the assets from the management, as well as sometimes with the other people who are controlling that property. But that does not mean that the resolution professional can touch the subsidiaries or third-party properties. Particularly, sometimes the material is giving only for the processing, etc. So those kinds of cases also frequently comes up before the court. Section 19 application is really helpful to avoid any potential liability. So all the professionals file it, but it doesn't get decided very soon. And the RP cannot be inactive just by filing section 19 application and take an extension. Nowadays, NCLT is proactively taking actions or sometimes asking explanation from the resolution professional what else the resolution professional has done apart from filing section 19 application. So section 19 is one part where only the management of ex-management or other persons are not cooperating. But this does not mean that the RP should not make other efforts to collect and collate that information. It might be from creditors, bankers, chartered accountants, ex-auditors, employees, etc. So they are always expecting the resolution professional to highly proactive. Composition of the COC is another sticky point where the voting rights are disputed inter se between the parties. Then appointment of the resolution professional and removal of the resolution professional is another challenging task. There are two questions which come repeatedly before the adjudicating authority. One is relating to the fee and another is relating to the reasons. Many of the people like to contest when they are removed from the position of the resolution professional. It is not advisable to contest that position or take reasons for the removal, because that may cast a kind of stigma or some negative impression of the RP for all times to come in all kinds of judicial record. So it's better that as soon as somebody is removed, by following a proper procedure, to hand over the records. That is something which should not be contested. The contestation should only be when there is some false allegation has been leveled. So it is only should be confined to, this is the kind of suggestion, it should be confined to removal of that allegation only and not otherwise. Otherwise, these kinds of thing that the person has been removed, new person has come, I haven't been given the reason, nothing explanation. Sometimes very strange case law happens. Recently, there was a case in the in the G Cinema insolvency, where the personal guarantor called the resolution professional in a particular hotel, and perhaps they had a tea and some communication between the parties, and merely for this reason, that resolution professional was removed. And this removal was affirmed by the NCLT. So the idea is not to take any allegation, but at the same time, these kinds of things should not be contested at all, unless there is some strong reason to contest such things. So 22 is then the litigation which comes is Section 29A. Section 29A is one of the most used section, but before reading this section, it is important to read the other MSME section 240. Just a second, give me answer. Because it deals with, it gives the right. First, the IBC came out with the notion that everybody can file a plan. Then the legislation came out with an idea that the person who were responsible for taking the company to this kind of financial scenario should not be rewarded. So they came out with a 29A. But the problem became aggravated because some of the small companies, there was no takers. And secondly, some of these insolvencies were not because of the promoters. And thirdly, there is a inbuilt policy framework where every government tries to protect the MSME. So therefore, 24A came. So 24A says that 29A will not be applicable. But they don't say that all the clauses of 29 will not be applicable. It only says clause C and clause H is not applicable. So only two clauses of 29A which are relevant for 240A. So clause C and clause H. Now we can read 29A. So in 29A, there are multiple disqualifications. These disqualifications ranges from undischarged insolvent, willful defaulter, just a second. So the first is undischarged insolvent, second is willful defaulter, third is C, which is classification of the people to NPA, which is not applicable in case of MSME, then SEBI restriction, then promoter preferred execution of the preferential transactions. Then H is regarding the corporate guarantee, it is not applicable, and all others are applicable. So basically, they have omitted only 2 sections which are not applicable in case of MSME. And even the MSME, the definition has been enlarged, and there is a judgment of now the court to say that the enlarged definition will come, and everybody who has become the MSME prior to institution of the insolvency proceedings as well as during the insolvency proceedings, if a company has been declared or become MSME, they are entitled to benefit of this section. This development happened because of the judgment, because first the NCLT took the view that if a company was not MSME, when the petition of section 7 or 9 was admitted, they took the view that such company cannot avail the benefit of 240A. Then the matter traveled to the Supreme Court, and the Supreme Court read 29A in such a manner because it starts with a proposition where it says on the date of submission of the resolution plan. So by taking that phrase into account, they came out that if the became MSME, because the financial criteria of becoming MSME was changed during the COVID period. So if the company became MSME, even after the section 7 or 9 has been admitted, they are entitled to take benefit of 29A. So this is the current prevalent view. As far as section 29A, only 2 sections which are not applicable to the MSME. One is regarding the NPA and another is regarding the personal guarantee. All other sections of 29A are applicable to MSME as well. So if somebody has executed a preferential transaction, somebody has an undischarged insolvent, somebody has been convicted, etc., SEBI restrictions. So all those people are ineligible from giving the plan. So are their relatives. Another interesting facet of this 29A is one of the disqualification relates to the preferential transactions. So if it is proved that the preferential transaction has taken place, then such person becomes ineligible. So normally those applications are not decided, and sometimes it becomes a challenge or a point of contestation between the 2 parties that whether the plan comes first or the avoidance transaction application is decided at first. So that's how the 29A operates, and it operates in relation to the 240A. Both the sections has to be read harmoniously, and it's a piece of beneficial legislation in the favor of MSME. So it should be read in the favor of MSME always. I think that's more than 1.5 an hour. So can we take a 5 minutes break? Or we continue?
So we'll take a break. We'll take a break.
Okay, let's take a break of, it's almost 3:40. So let's assemble at 3:50 again.
Right. Okay. Thanks.
I hope everybody is back. And thank you very much for starting that. So we have reached till section 30. In between, any of you have any questions so far, please feel free to ask. Or we can move to the next few sections, which are very contentious. The next section, which is submission of the resolution plan. There are multiple judgments now. In fact, since you are going with a complete training program, there are multiple teachers who must be coming for the different specific part of the IBC. You must have read many of the case laws which have been given by the different courts. Now, the central theme of the IBC, it is important to understand why these sections were enacted and how the judiciary is interpreting those sections by taking help of the language of the act as well as the minutes. Various committee has given various reports, how they are interpreting those reports. So entire IBC is collection of the claims, finding a suitable person who wants to take over the company again, and taking a resolution plan from him and implementing that resolution plan. So the most important steps comes is approval of the resolution plan. All of you are aware earlier the threshold was much higher, then it was reduced to the 66% because at many places there was no voting which was taking place. Now the resolution plan has to be tested on the touchstone of the dual test, which is section 30. Section 30, subsection 2, which is the most relevant section, and I want to read it. The resolution professional shall examine each resolution plan received by him to confirm that each resolution plan, 1, provides for payment of the insolvency resolution process cost, first requirement, in the manner specified by the board in priority to the payment of the other debts. So the priority, as long as it has been maintained, the first condition set satisfied. There is hardly any litigation as far as this is concerned. The most of the litigation which is coming is in the point B, which says, provides for the payment of the debts of the operational creditor in such manner as may be specified by the board, which shall not be less than 1, the amount to be paid to such creditors in the event of liquidation of the corporate debtor under section 53. So the valuation become important. 2, the amount that would have been paid to such creditors if the amount to be distributed under the resolution plan has been distributed in accordance with the order of priority of subsection 1 of section 53, whichever is higher. So there is a higher test. Well, the language is quite confusing at some point, but the broad parameters is there are 2 kinds of participants in the entire process which are not agreeable to the settlement which is proposed by a third party. One is operational creditor and another is the financial creditors who have dissented in the voting. The central theme of the section is, 1, the public money is involved as far as the financial creditors are concerned. Therefore, they must be given the priority. So, they must get their share. Then the people who are dissenting should not get incentivized from getting into the dissent. So, there cannot be same treatment of the people who are approving the plan and the people who are dissenting the plan. The person who are dissenting the plan should be given the minimum threshold of the liquidation value. That was the central theme of the section. But the things changed or things became complicated when the plan value is less than the liquidation value. So there is always an incentive to be in the dissent. So that's the commercial reality which has come into being because of these judgments. So what has happened that the original theme is sometimes contrary to the market realities, and that's why the litigation is arising. The secondly, order of the priority. So the operational creditors, CIRP cost, and the dissenting financial creditors has to be paid first. And the financial creditor who is approving the plan has to be paid anytime as per the plan. So there are two kinds of things which are happening. There is enormous amount of transaction structuring which is taking place in the resolution plan. So there are plans where the repayment, the payment schedule goes on for the 5 years or 6 years. There are plans where there are multiple classes which have been made that this will be done like this will be done like that, etc., etc. And sometimes some people, because of their sole vendor position, has been paid higher. So take an example, if there is some company which is dependent upon a raw material from an operational creditor. The operational creditor wants to take the entire money because if that particular material is not supplied, then the entire business operation will become unviable. So different kinds of structuring is taking place in the resolution plan. And the people who are not getting the amount strictly as per the overall scheme of Section 53 are challenging those plans. So the NCLT has taken a stand that they are not going into all those nitty-gritties. The wisdom of the COC is supreme. As long as the plan is approved with the 66% of the majority and the CIRP cost has been paid, and the second tech is that liquidation value has been paid to the dissenting creditor and operational creditor, they are approving the plan. So they have narrowed their scrutiny to a very fine aspects, and therefore they are making it binding. So there are many case laws on Section 30 and 31. I do not wish to trouble yourself or bombard with you with the case law. So what I propose to do, the end of this session, and thereafter I will give you a broad table which is prepared by the IBBI, which section-wise all the leading cases have been given. So you will find multiple case laws on each section wherever it has been decided. So it will be easier for you to grasp that thing. The purpose of this session is to have an interaction and to discuss like whatever the points are there. There is another challenge in the resolution plan is the claims which remain still for a long period of time, and then that pops up as soon as the new person comes up. So these are also challenges coming out of the insolvency proceedings. For example, if the land is allotted by some state authority, it's a leased land. When the successful resolution applicant is going to take possession of the land, they are demanding the dues despite the fact that no claims were filed. So in those cases, there are judgments from the High Court, NCLT and NCLAT, that particularly even from the Supreme Court, where the Justice Nariman used the famous expression of Hydra heads, like they can't, Hydra heads should not be pop up. So once the resolution plan is approved, it's final and binding. No new claims can be entertained. Secondly, what happens if the resolution plan is not implemented? So there are multiple litigations which are coming up where more
No,
time is
one
sought.
minute.
Yes,
I have one question.
thank you. Please ask.
Resolution plan is approved by COC or COC, no? After the resolution plan is approved by COC, no claims will be entertained.
That's
Right,
a
no?
different preposition. So there are two prepositions. One, after the approval of the COC, you are not entertaining the claims of the creditors which are filing claims to you. So there are series of judgments by
हाँ.
NCLT and NCLAT which says that after approval, you should not entertain the fresh claims unless there is some exception is created. The second limb of the same thing comes up. The people who are not filing the claims, but they have control over the assets. Take an electricity department. Take the example of the development authority. Okay. So these people control everything in that area. Okay. So even after approval of the plan by the COC and thereafter further approval by the NCLT, when successful resolution applicant is handed over the assets and he goes and open the lock and he says, now no electricity. You pay all the dues which has
But
incurred.
then that, but हाँ, okay, ठीक है, correct. Yes.
Okay. So
Yes.
that clears the thing. Okay. So these are the litigations which are popping up, and provident funds dues. There was a huge litigation of the provident fund dues because in some of the cases, the resolution applicant gave an X value of the entire amount. Say he is paying the 100 rupees for the entire company, but he has not factored in the dues that the provident fund dues are not part of the thing. Like they are not the CIRP because they are separate. So first NCLT forced them and NCLAT forced them to say that, okay, you pay over and above Jet Airways case, over and above what has been, and they agreed to pay. But once the resolution plan is coming, it is important for the RP to check all those things and make it clear that these things should not pop up. And if they pop up, the litigation is bound to happen. So normally the claims which are coming before the approval of the NCLT is regarding the creditors. Those claims do not pose significant challenge after the resolution plan approved by the NCLT. The claims which pose significant challenge are mostly from the statutory authorities, which they say that we have an overarching. Then there is another judgment in the Gujarat case, Gurja case, where they have a charge over the assets and etc. And the Supreme Court has taken a divergent view and the matter is again going on. So these are the things which are litigation prone and where the litigation might arise. And thank you for your question. That helps me a lot. Then approval of the resolution plan.
Thank you.
Thank you. So the approval of the resolution plan we have mostly discussed here. Then section 35, the power and duties of the liquidator. So the role changes. Now the same person can't be liquidator. Earlier, there was a good situation for the RPs who thought that if we can't recover in the CIRP, we will recover in liquidation. So now there is a circular which says that the same person can't be the liquidator. Be that as it may, the role changes once a resolution professional become a liquidator. It's no longer performing the duty of the collation of the claims only. It becomes a quasi-judicial authority in the sense that it determines the claims. But to what extent this duty goes on? So how far he has to become a judge in the case of the creditors? So there was various judgments, and ultimately, more or less, now the position has been settled that he can't follow all the rules of natural justice. He has to make a judicial assessment, but that does not mean the giving hearing to the parties or representation of lawyers and drawing up a judgment. He has to do his effort, find out and decide the claim. And if any party is aggrieved by that particular determination, it can go to the adjudicating authority. So that's how the process moves. So a resolution professional should always be ready once he decides the claim in the liquidation. The party has the right to go and make an application before the NCLT challenging the determination, which is a possibility in the CIRP, but which is as a matter of right here in the liquidation proceedings. So that's one of the fundamental changes. Then Another thing which the liquidator can do on the behalf of the corporate debtor is to institute the case for the recovery of the various dues from the other companies for realization of the thing, which is something more to capture the or enhance the value of the corporate debtor. Then there are provisions, there are hardly any litigation, other things, consolidation of the claims. There is an appeal which has been specifically provided in the section 42 against the decision of the liquidator. So any person who is aggrieved by the decision of the liquidator can file an appeal. That is also a fertile ground of the litigation, and all the appeals comes in that particular section. Then there is hardly litigation, any litigation as far as the prepackaged insolvency is concerned. And then voluntary liquidation also, there are no proceedings. Then the next chapter which deals with the litigation is section 60, adjudicating authority of the corporate persons. And this is one of the most used section in the entire CIRP process. Like every application on the top of it writes section 60 subclause 5. Why? Because it has been given the widest power and the interpretation by the adjudicating authority. I would like to read few of the clauses of this particular section in which the scope of the adjudicating authority's power has been widened. Subclause 5. What it says? It says that notwithstanding anything contained to the contrary, any law time being in force, any application or proceeding by or against the corporate debtor or corporate person. So it can be any application, proceedings by or against the corporate debtor. Anybody can file any application under section 60 subclause 5. 2. It can be in relation to what? Any claim made by or against the corporate debtor or corporate person, including claim by or against any of its subsidiaries situated in India. Anything. Lastly, C, any question of priorities or any question of law or fact arising out of or in relation to the insolvency resolution or liquidation proceedings of the corporate debtor. So therefore, this clause is so wide that if by any chance you feel that what kind of relief or which section will applicable in which you can file an application before the NCLT, this is a go-to section. You can file anything almost under the sun which has to related to the CIRP and corporate debtor, and this application is maintainable under this particular section. No particular class has been specified, only this thing can be done. So all the applications challenging the decision of the resolution professional, all the applications of the resolution professional against the apart from ex-management, because ex-management is specifically section 19, all the dispute between inter se between the financial creditors regarding the composition of the COC, etc., or any other thing, these applications are moved in this particular section. As far as this particular section is concerned, there is no specific criteria has been given that if it has to fulfill these criteria, and therefore all these applications will be maintainable. And challenge from these decisions goes to the NCLT to NCLAT. So in sometimes one has to be really careful while moving these applications as a resolution professional. Earlier or even till date, many of the resolution professionals files an application where no specific relief is claimed, or they are not taking decision themselves, but they are asking for guidance from the NCLT. The NCLT has a strong tendency to reject those applications. So one of the most vital part of these application is the prayer. And when you will get the chance to attend the proceedings, or if you are already attending the proceedings of the NCLT, you will find that the first thing judge looks at is the prayer. He doesn't want to see what is inside in the application and then come to the prayer. He wants to see the prayer. Whether the prayer, any tangible relief can be given to the person who is moved to application or not. If that is maintainable, then it will give that particular relief. For mere guidance, it should not be moved. Secondly, the appeals from these particular applications, which is decided by NCLT, goes to NCLAT. There is a very strict timeline, and that has been part of several litigation. The timeline is 30 plus 15 days in case of NCLT to NCLAT. And from NCLAT to Supreme Court, it is 45 plus 15 days, it's 60 days. Beyond that period, the limitation, if an application is filed, even the NCLAT does not have the power to condone the delay. So any person, including the resolution professional, has to be really fast when he wants to move before the NCLAT or the Supreme Court in this section. So it has been held that these time limits are absolute. Now, from what date it is to be counted is also important. So first, there was a line of judgment which stated that as soon as the order is uploaded, the limitation will start running from that date. So the people went and challenged that thing and saying that the limitation should start running from the date when they got the certified copy of the order. Ultimately, Supreme Court decided in terms of the Limitation Act that the time period, time taken in obtaining the certified copy of the NCLT is to be excluded in this period. So that is an exclusion which has been decided. Another controversy arose in all these proceedings, whether the date of e-filing is to be counted or the physical filing has to be counted. First, they were only taking the date of the physical filing as the date when the application was filed. Thereafter, a circular came in the NCLAT which stated that the date of virtual filing has to be counted. Now it is more or less, it has now been settled that the date when the actual filing has been done electronically, it will be taken as that date of the filing. So there might be delay in refiling, etc. Then delay, there is another principle whether a person is supposed to explain the delay of each day. So there are views and there are counter views, but some of the judges take a very lenient view as far as that 15 days limitation is concerned. Some of them would like to know the reason for each of those days, why that particular appeal was not filed. So this is Section 1, appeal to the appellate authority and the limitation period. After the NCLAT, the appeal goes to the Supreme Court. The same provision, it's a statutory appeal, but it is not a matter of right as such. So one must keep in mind that Supreme Court is different from all other courts. It is the apex court. It is not supposed to give reasons. So the Supreme Court exercises its jurisdiction in the appeal, even in a summary fashion. Means it is not a matter of right in the Supreme Court to be heard at length in all the cases. So there is a provision or Article 136 in the Constitution of India, where the people file SLP. SLP means special leave to appeal. In that jurisdiction, the Supreme Court only decides that this case is fit to be heard or not. If they decide that this case is fit to be heard, then only they hear it. So that's what they call miscellaneous days in 136, Article 136. However, in case of statutory appeal, this is one step forward. So it's an appeal which goes to the Supreme Court, and statutorily it is not an SLP, but an appeal. However, in practice, the exercise of this jurisdiction is also decided in a summary fashion. In the first day itself, the Supreme Court decides whether to hear it or not or dismiss it. One of the peculiar things you will see in the orders passed by the Supreme Court is that many of the orders, there is no reasoning as such. And one might question what is the reason that there is hardly any reason given by the Supreme Court's order. The justification or the reason, legal reason for that kind of practice is that there is no appeal beyond the Supreme Court. So there is no court above the Supreme Court who is going to test the reasoning whether it is right or wrong. And it is the final court. And therefore it is apex. Therefore, in the miscellaneous orders, even in the IBC cases, you will not find detailed reasoning for the judgments or the conclusion arrived. So that's the matter of the practice. So that's the fundamental shift from the NCLT and NCLAT, where most of the applications, a notice is issued, the other party files a reply, there is compliance of natural justice, and post compliance, there is a reasoned judgment which can be scrutinized by the winning or the losing party, whether that reasoning is correct or not. And so it can be taken into appeal by the adversely affected party. But there is no such system as far as the Supreme Court is concerned. Any questions so far, sir, by anyone? Okay, I assume that all of you have understood everything. And there are no further questions. Okay, so there are, IBC is not only a law which only have the civil consequences on the property, it also has the penal consequences. These penal sections are are not used frequently, but one must be aware of them. And these are the litigations which might arise from it. One is punishment for falsification of books of the corporate debtor. What is it? It's very interesting section, but hardly anybody files an application in this. On and after the insolvency commencement date, where any person destroys, mutilates, alters, or falsify any books, etc., he shall be punishable. No action is being taken, no application is being filed, but this is something which can be used, and these are the proceedings arise after CIRP. Punishment for willful or material omissions from the statements relating to the affairs of the corporate debtor not being used. Punishment for false representations to the creditors. This is also something which is hardly being used. Punishment for contravention of the moratorium or the resolution plan. Yes, sometimes the application are being filed. Punishment for false information furnished in the application, nobody is using it. Punishment for non-disclosure of the dispute of the debt by the operational creditor, not very often used. Punishment for providing false information in the application made by the corporate debtor, punishment for offensive prepackaged insolvency, etc. So there are multiple penal sections, and in all these penal sections, the proceedings goes before a special court, which decides the penalty. So far we have covered most of the sections which relates to the corporate insolvency resolution process. Now, there are few sections which I propose to deal, which is still contentious and which is the most often litigated, is 94, 95. The beauty of these section is the moratorium. So these sections are used as a weapon as well as the shield by the personal guarantors and the financial creditors. So far as the insolvency of the individual is concerned, it is limited to the person who have given guarantees to the corporate in respect of the corporate debtors. So only limited part has been made operational. There were multiple challenges in these sections by the people who were adversely affected before the NCLT, NCLAT, Supreme Court. They failed in all respect, and constitutionality of the provision in the High Courts and Supreme Court was upheld. The consequences of these litigation was that as far as moratorium is concerned, that got triggered as soon as the application was filed. And because of the moratorium, the proceedings of the recovery came to a standstill. These sections restarted, the proceedings in these sections restarted only when the Supreme Court upheld the constitutional validity. That happened twice. There was a stay and there was a second stay, and these proceedings remain in abeyance for now. The second litigation in those sections was regarding right to be heard. So all of the people whom those notices were given challenged those proceedings on the ground that when these proceedings are being initiated, we have not been given the right to be heard, and an RP is being appointed. So our rights are prejudicially affected. This litigation also went up to the Supreme Court, and the Supreme Court decided that till the resolution professional file its report, whether to admit the insolvency or not, there is no right to be heard. So that controversy also got settled. Now, a third set of controversy which is still coming up is invocation of the personal guarantee. So when was the personal guarantee was invoked and when it could be invoked? So as far as the personal guarantee is concerned, the liability of the guarantor is coextensive with the borrower. This is the broad principle. Coextensive means as long as the liability of the borrower remains there, the personal guarantor is liable to make good that payment. There are some sections in the Contract Act which has a serious implication on this case. But the point on which the majority of litigation is being fought today is that the default has taken 10 years back. The proceedings were initiated against the companies 10 years back. But no proceedings were initiated against the personal guarantor. When these companies went into the insolvencies, these insolvencies resulted into the resolution plan and liquidation. When the financial creditors were unable to realize the full amount in these proceedings, they are filing Section 95 against these personal guarantors. So the first issue which is coming up for the consideration before the NCLT and NCLAT stage right now is the limitation. When was the personal guarantee was invoked and whether that guarantee can be invoked again and again or not. So one has to be really careful while making the report, because that report is going to be tested on this touchstone to whether that is due or payable or not. And that justification has to be given by the resolution professional, because the resolution professional is the one who is defending those proceedings at that point of time, that those proceedings should be initiated. Secondly, the major challenge for the resolution professionals in these proceedings is the fee part. There is lack of clarity how this will be implemented.
Can I ask you a question here? Or should I reserve it for the end?
I missed the first line. Could you please repeat, Mr. Stefan?
Can I ask a question I asked?
Yes. Most welcome.
So with regard to the default date and due date.
Yes.
With respect to a personal guarantor's case, Section 95 case.
Right.
Is the default date will still remain as the same default date of the CD or after invoking the guarantee of the personal guarantor?
Great question. So the default date in case of CD and in case of personal guarantor are two different dates. because the liability is coextensive, so after the default has taken place, the banker will give the notice to the personal guarantor to pay the money. That would be the date of default in respect of the personal guarantor. The law has been settled long back by the Supreme Court as far as this issue is concerned. So it is wrong to assume that as soon as the CD defaulted, the limitation get triggered. No, the limitation gets triggered on the date when demand is made from the person that you pay. Okay. And
Invocation of guarantee date is the date of
default.
due date for the PG.
Right. And there is another legal issue there is continuously running guarantees. So some of the guarantees are couched in a manner where there can be multiple notices. So with each notices, the limitation gets revived. And the Contract Act says that if there is a variation in terms of the original contract, then the guarantors get released. So some of the old documents have not been drafted properly, but new document says that irrespective of the variation, that guarantor will remain bound by the contract. So once when somebody is examining those guarantees contract, one has to be very careful regarding the wordings of that contract and how it will work. Hope that answers your question, Mr. Stephen.
Yes, sir. Thank you.
Thank you very much.
Sir,
Thank
in one of my case, there was the guarantee was invoked, and then the personal insolvency application was not filed. Now, again, after 2.5 years, the guarantee, the notice has again been sent to the personal guarantor. So, if that had been after 3 years, then the limitation would have been there.
Yes, so the again you have to see the terms of the guarantee, whether if that is a continuous guarantee, will be no question of limitation, because multiple notices could be given in some of the guarantees. But if it is only once and there is no such continuous guarantee, so as soon as that first notice was given, the limitation gets triggered, and non-payment, and if 3 years no action was taken, that guarantee will become time barred.
Yes, so that again it's 3 years from the first notice.
It will always be the first if it is a continuous guarantee. Multiple notices can be given, and with every notice 3 years. If it is not a continuous guarantee, then first notice and 3 years. There cannot be a second notice.
Okay. So I have to go through the terms of the guarantee.
Yes. And then you have to see the provisions of the Contract Act. What is the continuous guarantee, and match the case laws.
Okay.
And that question is still pending. So,
okay.
So multiple such cases are coming before the NCLAT after being different judgments from the NCLT, and the landmark judgment is yet awaited, from the Supreme Court. So thank you, Sunilji, for the question. Any more questions? I assume that everything got resolved, and all of you are free to ask more questions after the sessions as well. And you are most welcome to my office for tea, coffee. I will try to resolve the questions as much as possible. So those are broadly those sections where those are heavily litigated in the entire IBC. So I have not bothered with you all the sections. It is possible that litigation can be initiated in each and every section of the IBC. Many of the sections, there are very few litigations. In many of the sections, there are many litigations, so we tried to cover the broad concept. I haven't bothered you with the case laws, and the volume of the case laws are increasing day by day, and it is unless you are working on a specific topic, sometimes it is very difficult to be on the top of everything every time. So if there are some omissions or some corrections, you are most welcome to suggest. Any more questions?
I have one question, sir.
Yes, sir.
Regarding some forensic audit, that the resolution plan has been approved by the COC and by the executing authority. So after approving the resolution plan, can we file the application before the executing authority for forensic audit or not?
Forensic audit application is, I'm not able to get the question, but I'm trying to, what my impression is. You can prosecute avoidance transaction applications if that right has been reserved in the resolution plan. So earlier there was a controversy whether the successful resolution applicant can do this or not. So there was a clarification kind of sort, or the law has mostly settled that that has to be built in the resolution plan. Only then it can be done. But if I understood your question correctly, you want to move an application post approval of the resolution plan for forensic audit of the company. That experiment has not been done so far to my knowledge in any of the cases, because that will open a Pandora's box. If you, so what is happening is, if this practice is the consideration which will come before the court is, if this is allowed, every resolution applicant will say, no, the information given to me is not correct. And secondly, there is a siphoning of the money. Okay, so I will go all after that. That is not the purpose of the IBC, to find out the people who were doing the business in a certain manner as per the prevailing norm as the past years. So there is a time limit, 2 years, 1 year, only these transactions, this is duty of the RP. Further, that application itself will cast a shadow of doubt on the functioning of the resolution professional who was working with that company, why that particular transactions were not identified by you within the specified period of the time. So legally speaking, if we see the provision, then the provision will be 60 subclause 5, which will be applicable. So obviously you can file an application. Nobody can prevent you from filing such an application. Okay. The next question, who will be the respondent here? There will be at least 2 parties who will be respondent here. One is the resolution professional who failed in his duties, and 2 is the people who were managing the affairs of the company. Okay. If we take it further, now it will be very difficult to convince the NCLTs to say that first allow us to do such things, which will allow me to initiate further proceedings against them. I feel it will be a difficult task or uphill task for the lawyer to convince or get that order and then allow the other application. Then you will be filing applications when? After maybe 2 years.
Yes.
Assuming that you file an application today, Section 65 asking for the forensic audit, and you are extremely fast, within a month, you scrutinize every data and you file the application for avoidance transactions.
Basically, what happened that in my practical case, we have received the resolution plan, and application of the resolution plan is submitted, and only the one argument has been held before the executing authority, and the one argument, the resolution plan has been reserved. And the order reserved and the pronouncement has also been made within the 2 weeks of the submissions of the applications and reserve the order. So the time is basically required, the forensic audit, they take some time. So we assume that the applications of the resolution plan will take the 3-4 months. or only the 1 month the resolution plan has been approved by the principal bench.
So you are lucky, sir. You are lucky, sir.
Yes.
But the reality is that avoidance applications, if we take the quantum of the application and the number of judges, it will take around 7-8 years to decide all those applications.
Yes, I agree with you.
So you can definitely file, but to get out of these applications, anything, I have a real doubts about that.
Before filing of the application, it is necessary to get the very legal opinion in this matter. So after getting the legal opinion, then take the action.
Right. You must get a legal opinion and put those person in charge of getting the relief.
Yes.
If you get a favorable one. Anyway, that's a difficult task and uphill task. And thanks, Sunilji, for your questions.
Thank you very much.
Any more questions, sir? Okay, so far, all of you have been a wonderful audience. You have tolerated the monologue of almost 2.5 hours or more than that. One person speaking with little X expression and
I have a last
already
question.
know. Yes, most welcome, sir.
The issuance of a Form G, for example, if Form G was issued and resolution applications were invited, and further to that, if the COC decides that there were not enough resolution applicants, and COC goes for another round of issuing Form G, and can the previous resolution applicant challenge such a position that COC deciding to go for a fresh Form G and issuance of a fresh Form G and stuff?
Okay, so this is a squarely covered preposition. So this has happened in multiple cases. Now, the NCLAT as well as the Supreme Court has taken the view that there is no vested right in the resolution applicant to the challenge the resolution plan. So in one of the cases, almost identical situation has arisen where one person was the kind of L1, like his resolution plan was selected, and thereafter another Form G was invited for whatever commercial reasons. And thereafter the another person was chosen. That proceedings were actually challenged, but that person failed in that challenged. So right now, there is no doubt because his resolution plan was not approved as such, because the COC decided to come out with the fresh Form G. So he doesn't have a pre-existing right. And since during the two Form Gs, the IM might change as well as the conditions which might be imposed by the COC for the resolution applicant. So normally, unless there is some grave injustice or some collusion or fraud, the NCLT, LAT or the Supreme Court will not interfere with the commercial wisdom of the COC.
Okay, sir. Thank you.
Thank you, sir. So thank you very much to all of you. And now I request ICSI coordinators to please close the session so all the people can enjoy their evening tea or coffee or snacks, whatever it is.
Thank you so much, sir.
Thank you, sir. Anybody there from ICSI?
Yes, sir. Can we conclude now?
Yes, ma'am.
Thank you very much, sir, for such a nice session. Thank you very much for wonderful session. Sir, you are requested to share the presentation with us so that we can share with participants.
Yes, I will share in 2 days.
Yes.
Thank you very much.
Thank you, sir. Thank you very much.
Thank you, sir.
Thank you, sir. Thank you, sir. Thank you very much.
Very much, sir.
Thank you.